Hi, everyone. It's Tara Damchuk here with the Blue Water Area CVB. Thank you very much, Tammy, for that update. I can't thank you and the rest of the board for everything you do. You guys always put together the best education programs. You stay connected with your members. So on behalf of probably all your membership, I thank you for all you guys do. It really means a lot. But I am one of your keynote speakers today. And I just wanted to give you a short update on the Blue Water area. We are currently, during our downtime, our convention center put in a new HVAC system. They updated all our restrooms so they're touchless. We also got some of those disinfecting guns. So during your turn down, if you have breaks, we can go in all the rooms and sanitize those quicker and faster so you can get into your next meeting in a timely manner. We also, our museums are doing wonderful things. They know people are wanting to be outside, so they now have walkable tours. So right outside of our convention center, we have 3 sunken ships. There was also an airplane crash as well that is in Lake Huron. So they do wonderful tours where you walk along the boardwalk and they will tell you all about the history of Port Huron and those sunken ships. It's a really fun tour. I've been on it. They do a great job at the museum. And I just wanted to play a short video before I introduce our next speaker. And I know a lot of people are doing virtual meetings, and that is great, but go visit your areas in Michigan. Go see different things in the area. Come visit us on the Thumb Coast, and just have a little staycation in Michigan. We recommend it. And I'll play you a short feel-good video before we introduce our next speaker. While we know things may look a little our next speaker. Jeff Tenenbaum is one of the nation's leading nonprofit attorneys and also is an accomplished author, lecturer, and commentator on nonprofit legal matters. As managing partner of the nationally recognized Washington, D.C.-based Tenenbaum Law Group, Jeff counsels his clients on the broad array of legal issues affecting trade and professional associations, charities, and all nonprofits. For 19 years, Jeff practiced law at the Vanderbilt Law Firm and chaired its nonprofit practice for most of the time. Among numerous other honors and awards, Jeff was the 2006 recipient of the American Bar Association Outstanding Nonprofit Lawyer of the Year Award, and is one of only 5 lawyers in the prestige U.S. Legal 500's Non-for-Profit Hall of Fame. Jeff is the author of an ASAE published book, Association Tax Compliance Guide, and currently serves as the chair of the American Bar Association's Trade Professional Association Subcommittee on the ASAE Legal Advisory Council and Public Policy Committee. So as you can see, he is very qualified to answer your questions today. So please be prepared with your questions, and I'm excited for this session. Jeff?
Thank you very much, and good afternoon to everyone. So this is going to be a bit of an unconventional session for your conference, I would presume, in that I have no PowerPoint presentation. I actually have no prepared remarks. But what I'm going to do for the next 45 minutes or so is answer your questions on any kind of association legal issues. But primarily and principally focused on COVID-related issues, relating to anything from meetings and contracts, from the cancellation front to the in-person meeting front, and everything in between, as the association community has kind of progressed down this path over the last 12 months since the onset of the pandemic. How to mitigate liability risks, the role of liability waivers, the things that you need to do to protect your association, to any governance issues, copyright issues, unrelated business income tax issues relating to virtual trade shows, antitrust concerns about discussions on your online forums between your members on antitrust sensitive pandemic related topics, and kind of anything else in between. So I'm throwing out there are some ideas for you guys to start thinking about, and pose your questions to me in the either in the chat or by unmuting yourselves and posing the questions to me verbally. Either one works, but we want to make this. I'm going to kind of try to do this in a rapid fire fashion. For some of your questions, I'm going to take a few minutes to kind of give you the basic background and context to kind of set the stage before I get into specifically answering your question. Others are going to be kind of shorter and sweeter answers, but I want to try to make sure we cover as much ground as we can. And I really focused on trying to give you kind of some very practical guidance and tips and suggestions for moving forward and dealing with the challenges that all of your associations are dealing with these days. And just so you know, my perspective on all this, as you heard, I've been practicing law for 25 years in DC, all of it representing associations and other nonprofit organizations, primarily associations, on a wide array of association legal issues, primarily serving as outside general counsel. My colleague and I started our law firm beginning of last year, and not surprisingly have spent much of the last 15 months counseling and helping associations with a variety of legal issues stemming from the pandemic. We represent about 350 organizations right now. And so all of the experience, not just from the past year, but from all of my career, informs all of the discussion that I'll be having with you guys here today. So does anyone have any questions to get us started? And if not, Diana, I know you had some questions that were posed in advance to you as well.
Yeah, Jeff, they have to ask their question in the chat, so I'll have to ask them to you.
Okay.
The first one is from Shelley Long, and she said, do we need to have participants in any event we do sign a COVID waiver saying that we are taking all precautions, but they realize they're taking their chances, so to speak?
Yeah. Okay. Great question. I get it all the time. And first thing, because I'm going to reference these a lot, I don't think I've sent them to you, Diane, but I'm going to send to you guys links to a number of different articles. I've always written a lot of articles, but I wrote a number over the last year on pretty much all of the pandemic-related legal issues that we'll likely be talking about today. And they get into a lot more detail, and those articles also have links to other resources. I'm going to send those to you so you can share those with the group, and that'll be a good resource. One of those is actually an article about liability waivers for association conferences in connection with COVID. And that contains a model liability waiver that you guys should feel free to utilize or adapt for your own associations. So the short answer to the question is absolutely, it's a no-brainer that you should ask attendees at in-person conferences as you start to have in-person conferences. And there are a number of associations, incidentally, that have already started having smaller in-person conferences in cities and states where where they're allowed to do so. It's still not lawful to have larger gatherings in a lot of cities and states, but it varies across the country. And there are in-person conferences being held. There are a number being planned for the summer and the fall of this year. And one of the things that it's a no-brainer to do is to say to your attendees, we are asking our attendees to sign. You've probably already seen it. You know, you go to your hair salon, or you go to various other places where you're purchasing services, and they ask you to sign some sort of a COVID liability waiver. It's becoming the norm, and I think it will, including at association conferences. It's a no-brainer in that it is the attendee saying, I am knowingly assuming some risk by attending your conference. I recognize that there's no 100% complete way that you can guarantee my health and safety from COVID. And so I recognize that there's some risk, and I agree to hold you, the association, and sometimes the venue, if the hotel or convention center is asking for a liability waiver as well. I agree to hold you harmless and not bring any lawsuit or other claim against you if I later contract COVID and believe I contracted it at your event. Now, that being said, is that the end all be all that's going to absolutely protect you from all liability in the event that someone does contract the virus at your event and can prove they contracted it at your event? No, liability waivers get tossed out by courts all of the time for a variety of reasons. They don't always work, but a lot of times they do, and it's a no-brainer that a well-crafted liability waiver is an important tool in the risk management process. But it's not the only tool. And one of the articles I'm going to send you it has like the top 5 things that you need to do as an association to mitigate your liability risk from holding in-person meetings. Liability waivers are one of those 5 tips, but it's not the only one. And so the basic legal construct here is, was your association negligent in how it conducted its meeting? These are all about negligence claims. If someone was to contract the virus, and if they could prove, and frankly, the only real way to prove is if you had like a cluster, an outbreak, where a number of people at your conference contracted the virus. That's probably the only practical way that someone could prove causation that they contracted it at your event. But if that happens, and there is precedent for that happening, it actually happened at a conference here in the DC area last, I think, February or March. There is precedent for being able to prove causation. Someone would have to prove that your association was negligent in how it went about holding the meeting. So how do you prove that you're not negligent? Well, what you want to be able to show is that you met the prevailing standard of care that existed at the time for holding events. So what is that standard of care? Well, the standard of care, it's a legal term. It's part of a negligence claims. It's one of the things that someone has to prove, that you failed to meet the prevailing standard of care. Where do you look to that? Well, the first thing you look to is, what are any mandated requirements? There's really not any on the federal side for most association meetings, but there are at the state and local level. And frankly, as more and more states and cities start to continue to open up their economies and allow larger gatherings to take place, they are also coupling them with certain requirements on how you have to conduct large gatherings and things like that. So anything that's mandatory from the city, state, county, you want to make sure you're following. But it doesn't stop there, because most of the guidance that's out there in this area is not mandated. It's advisory in nature, but it's still relevant to whether you're meeting the standard of care. The number one place to look on guidance is the CDC, the U.S. Centers for Centers for Disease Control. They have put out some very detailed guidance for how you can safely put together large meetings. That article, one of the articles I'm going to send you, has links to the current CDC guidance, which CDC continues to update, by the way. It's a long list of all of the things that you want to do to hold kind of meetings that are safe and healthy environments for your attendees and your staff. And you want to follow those things to the greatest extent possible. When I say greatest extent possible, because there are costs and burdens that go along with a lot of these things. You're likely not going to be able to do everything, but you want to do as many of the things as you can. And this is really important. And I know there's a number of you guys on this conference from the from the hospitality industry as well, from the hotel and convention center community and whatnot. A lot of the guidance, I'd say more than half the guidance in that CDC guidance document actually relates to the venues, to the hotels, convention centers, restaurants, where banquet halls and other things where meetings are being held. They relate to things like sanitation and airflow and other things like that. And so as an association, you want to get the venue, the hotel or whatnot, to commit that they are going to follow that guidance to the greatest extent possible. And you want to get them to commit in writing. Ideally, you'd have it in your contract with them, but at a minimum, make sure you have a written correspondence, like an email trail, where the hotel is committing to do X, Y, Z things. In fact, if I were you, and what some of our clients are doing is they're going through that CDC guidance. They're making a list of everything that they think they can reasonably ask and expect the hotel to do. I'm just using hotel as an example of the venue. And then putting that list together in an email and saying, you hotel, please agree that you will do all of these things in connection with our meeting. That's another way to show that you are not being negligent, because you are putting the onus on the venue to do the things that they need to do that you cannot do. Other things that you can do, for instance, like enforcing mask wearing, if you have a mask wearing requirement in public areas, it's the association staff and leadership that's going to enforce the mask wearing requirement, not the hotel staff. Social distancing requirements, you might impose on the hotel an obligation to set up seating and tables and other things like that in a way that facilitates appropriate social distancing and any occupancy limitations that the state or city has imposed. But it's going to be on your staff and leadership to ensure that people are keeping proper distances and things like that. So if you do all of these things and you have liability waivers, it's going to be extremely difficult. Even if someone can prove that they contracted the virus at your event, it's going to be extremely difficult for them to hold you liable for that. One related issue that there was a question about insurance. So the two different types of insurance have come into play a lot in COVID times. The first is a separate issue, event cancellation insurance, and I'll talk about that later when we talk about meeting contracts. But the other is what's called commercial general liability insurance, sometimes referred to as CGL, commercial general liability insurance. That's what some people call slip and fall insurance. And it's the insurance policy that basically covers a variety of claims, including for bodily injury and property damage. And it's the type of policy that typically will provide coverage for claims meaning lawsuits or other legal claims that arise in connection with your conferences and meetings. And so CGL policies are designed if someone literally has a slip and fall accident at your meeting and sues the association as well as the hotel saying you were negligent in not having a safe environment or slippery floor, you didn't fix a water leak or whatever the case might be. That's the policy that generally will provide coverage. The one thing to keep in mind is that the leading insurance carriers, from what I understand from a number of insurance brokers and clients of mine, as the CGL policies are coming up for renewal, the carriers are including COVID-related exceptions so that any COVID-related claims would not be covered by the policies. So if you have a policy that was written prior to the pandemic, it will not have an exclusion for COVID-related claims. And if that policy is in effect at the time that you have an event, it should cover COVID-related claims. Insurance carriers are not allowed to just make an amendment to a policy midstream. But once that policy expires and it comes time for renewal and they give you a new proposed policy, that's when they're writing in these COVID exclusions. So that's something to keep in mind. Of course, the CGL policies will still cover other non-COVID related claims like the slip and fall accidents and other things like that. So I know that was a long answer to a short question, but I hope you found that helpful.
So another question from Lori Nixon is kind of a follow-up. Going forward after COVID, is it advisable to have and require in-person attendees to sign a generic waiver in reference to health and safety issues?
So frankly, it's not so much, it never hurts to have a liability waiver. It depends. You got to think about what sort of risks are we talking about? Are we talking about the literal slip and fall? Are we talking about, harassment? There's lots of different claims, and I deal with these things often on the back end because I get brought in when different bad things happen at a meeting or conference. Some of that stuff, you're not going to be able to have an effective liability waiver. A court just wouldn't enforce it. Could there be some reasons to still have some general liability waiver that attendees agree to? Sure, I could think of some. Perhaps not a bad idea. But to me, what it does raise is an important point, and this has become more common in recent years, and that is for associations to have and adopt and promote to everyone a code of conduct at your meetings and conferences that all attendees agree to be bound by. So this is very different from a liability waiver, but it's basically saying I, attendee, agree to abide by your code of conduct. I think this originally started kind of arising out of a lot of harassment-related issues that have occurred at meetings and conferences, often when alcohol is involved, but involves a lot of other things as well in terms of just abusive behavior between attendees and other things like that. And so having an attendee code of conduct. Frankly, some associations have even adopted one for their virtual events as well. I think it's equally important to have it for virtual events as well as in-person events. They're going to look a little bit different, but having a code of conduct, getting your members and your attendees as part of the registration process to say, ideally have them click and accept a separate, some kind of pop-up window or something like that if they're doing it online, where they agree to be bound by the code of conduct. Certainly have it be part of your overall terms and conditions as part of the registration that they agree to. I think that's a very important thing to do. And then if you have attendees who are engaging in bad behavior and you want to, suspend them from attending your next conference or conferences for a year, or banning them for life or whatever it might be, you're going to be on firmer legal ground to do so in the event that you need to do that. One other kind of related issue, I know I'm going a little bit off topic, but these are issues I deal with all the time, and these are important, is that as part of those overall terms and conditions, whatever you want to call them, that your attendees are agreeing to as part of the registration process, another thing that's important to put in there is a release of their right of privacy that basically gives you, the association, the right to film, take pictures, etc., of attendees at the conference and then use them for your own purposes. This is not a copyright issue. A lot of people think it's a copyright issue. Copyright in that situation would belong to the photographer or the videographer who's taking the photos. And if they're hired by the association's contract with the photographer or videographer would typically assign the copyright rights to the association. But this is something it's a common law right of privacy that everyone has. Famous people have what's called a right of publicity, but for the rest of us, it's called a right of privacy. And if you essentially technically do not have the right to film or photograph someone at your event and then use it for your own purposes without their permission. And so instead of going to each person individually and asking for permission, the best practice for years has been to throw that into your terms and conditions that people are agreeing to as part of the registration process.
Do you have an example of a code of conduct you could share that we can customize?
I do, and I will share some. I know I've shared ASAE has a virtual code of conduct that I think is not bad, and I will share a copy of that. And then we've worked on some codes of conduct for some clients that are on their websites and whatnot, so I can share those. But yeah, I'll include that in stuff I send over to you guys.
Thank you. How do we enforce the current safety protocols, such as wearing face masks, particularly as more and more people get vaccinated and don't feel they need to wear them anymore?
Yeah, so I mean, this is a tough one. But right now, I think what you want to do, again, it's about meeting that standard, the prevailing standard of care, which will change over time. It's already changed since a year ago, but it's going to continue to change. Right now, to me, you want to follow the CDC guidance. And as you guys know, CDC put out some new guidance about a week or so ago, that said in certain small gatherings with family or other people that are vaccinated, it's okay to be together without masks. But in every other situation, including larger gatherings, for now, it's still important to wear masks because we know the vaccines are not 100% effective. We also don't know for sure the extent to which the vaccines prevent someone from being a carrier of the virus. Even if it doesn't infect them, it doesn't mean that they can't infect others. And so until the science and the CDC guidance says otherwise, that is exactly the kind of guidance you're going to want to follow. You want to have a mask requirement, and I'll explain something else in a second. You want to have a mask wearing requirement in all public areas, obviously not in someone's private hotel room or whatnot, but in any public areas. And it's going to be on your association staff and leadership to enforce it. And if you see someone walking around without a mask, you need to remind them to put it on. And if they absolutely refuse and they become kind of repeat offender, then you may have no choice but to ask them to leave the conference. Now, one thing I forgot to mention earlier about the liability waiver, the model I'm going to send you has two parts. The first part is the liability waiver itself that I described. The second part, though, is the attendee agreeing to abide by all rules that you put in place for attendance at the conference, including mask wearing. So you're having the attendees say affirmatively, I agree to follow all of your rules, all of your terms and conditions. I have some of those written specifically into the into the liability waiver. You could also cross-reference, some associations have another set of rules that they expect all their attendees could be part of that code of conduct to follow, and you kind of cross-reference it or link to it. But regardless, you want to have the attendees affirmatively agree that they will follow all of your conditions for attending the conference. That puts you on even firmer legal ground in the event you need to, say, kick someone out of the conference for not following your rules. Other questions, Diane?
Let's see. How can members use online forums to discuss how they are responding to the pandemic without running afoul of the antitrust laws?
Okay, so probably most of you are thinking, how do the antitrust laws have anything to do with the pandemic and what we're doing here? But believe it or not, and I actually just spent last night putting together a staff training, antitrust training session for one of my trade association clients. These issues are definitely top of mind. But believe it or not, during the past year, during the pandemic, we've counseled some associations on problematic discussions that were occurring on their online forums, like their listservs and other, Collaborate and other online forums that the association sponsors for use by the members. Now, the antitrust laws are designed to promote and protect, fulsome and free and fulsome competition, with the idea being that it's better for consumers, it helps to lower prices when you have full competition between competitors. Where competitors, however, agree to do certain things that are anti-competitive, in some cases it can violate the antitrust laws. The most notable one and most serious one being something called price fixing, where two or more competitors, and most members of your associations are going to be competitors. So you're at a higher risk as an association to begin with, because you're a combination of competitors. And if two or more of your members / competitors are, for instance, talking about and potentially agreeing on prices or fees that they are going to charge, that is strictly illegal. It's what's called a per se violation of the antitrust laws, and very, very serious. Despite the fact that it might have very good motivations, there's no pandemic, there's no COVID exception to the antitrust laws. And so if you have competitors talking about fees or prices, we've had to deal with so many extra costs because of COVID. We're thinking about raising our prices or fees. What do you think about that? Do you think we should do this? Maybe even if there's not a formal agreement in that online communication, even a discussion of that topic followed by coordinated or concerted action between members can be used as evidence of a price fixing violation. And so what you want to do is you want to have a really good, firm, and clear set of rules on your online communication forums that people are required to click and accept when they first sign onto the forum, when they first join it, and that you distribute, send out to everyone on the list, at least once a year, if not more, reminding them of all of the basic rules of participating on the forum. One section of that set of rules should deal with antitrust issues, the kind of topics that are off limits, any discussion of prices or fees, or anything that factors into prices or fees, including staff salaries and things like that. Strictly very dangerous discussions to allow members to have. So your rules should prohibit those sorts of discussions. Other things that you would put in there, don't post anything that infringes anyone's copyrights, don't post anything that infringes anyone's trademarks, don't post anything that invades anyone's right of privacy, don't post anything that's defamatory to others. Those sorts of things are all the kind of things you want to have in your rules. Don't use the forum for advertising and promoting your products or services, that sort of stuff as well. Some legal, some quasi-legal. So that's one thing. Having it in your forum rules and having people click and accept they agree to those. And then the second part is when something comes to your attention, you meaning like association staff, that there's some problematic discussion on the forum about any of these issues, you need to take prompt corrective action. You need to take it down. You need to warn the individuals who made the problematic comments. If they are repeat offenders, you need to take some disciplinary action against them, suspend them from the forum for a while, perhaps even kicking them off the forum if it's a really repeat situation. That sort of stuff will go a long way toward protecting your association from any related liability risk.
Okay. As states and localities open their economies and associations, as they consider opening their workplaces, what are the key liability considerations to protect both the association and its employees?
Okay. So workplace reopenings, it's happening already in a number of places. It's going to happen more as we get deeper on into the year. I think especially after Labor Day, you're going to see a lot of associations, at least to a certain extent, reopening their workplaces, their offices. Maybe not 100%, but I'm seeing so many of my clients making plans for that already. So first thing is, you get the same basic construct as you have for meetings. It's a negligence standard. If you're worried about risk from someone contracting COVID at your office, are you as an employer doing everything necessary so that you are not negligent in how you are operating and opening your workplace? Here, the CDC has some guidance on this, which is helpful, but the most helpful guidance actually comes from another federal agency called the Occupational Safety and Health Administration, OSHA, which you've probably heard about. And there's an article of mine I'm also going to send you about workplace reopenings and how to mitigate your association's liability risk. It contains links to the primary OSHA guidance on this topic. You absolutely want to follow that guidance to the greatest extent possible. There are costs associated with a lot of the recommendations. Of course, some things can cost a lot, some things don't cost much at all, but regardless, you want to follow that guidance to the greatest extent possible. And to the extent you do, you'll go a long way toward helping ensure that your association is not negligent in the event that an employee alleges or claims that they contracted the virus at your workplace, or not just at your workplace, but doing work like traveling for work, whether it's in-town travel, out-of-town travel, whatever the case may be. You want to be sure that your policies and procedures and practices are not negligent based on the prevailing OSHA guidance. And of course, any other mandatory state and local guidance that applies to workplaces. And there is quite a bit of that out there in various states and cities. Some people have asked me about liability waivers for employees. Basically, they're invalid. It's illegal in most states to have an employee sign a liability waiver that would waive their rights to workers' compensation benefits, which is largely what we're talking about here. So, you could have them sign it, but it's going to be null and void. So I would strongly advise against that. Another question that I actually should have brought up earlier with respect to in-person meetings, and actually let me address it on the in-person meeting front, and then I'll address it in the workplace front, and then we can move on to something else. And that's mandatory vaccination requirements. We're getting this question a lot. We're not quite there yet, but hopefully, according to what the president says, by May 1st, and he wants all states and cities to make vaccines available to anyone who wants them. Of course, doesn't mean everyone who wants to is going to be vaccinated by May 1st, but it hopefully means that everyone who wants to will be vaccinated, within 30 or 60 days after that. So we're not too far off, hopefully, from a point where everyone who wants a vaccine can get a vaccine. So then the question arises, can we require proof of vaccination as a precondition to attending our event? And the short answer is, with one exception, which is the Americans with Disabilities Act, which has a section in Title III which applies to kind of in-person meetings and conferences. There are some kind of ADA, Americans with Disabilities Act wrinkles that could apply, but ADA issues aside, it generally would be acceptable for you to, if you wanted to. I'm not recommending that you necessarily do this. And a lot of associations are saying, hell no, we're not going to do this. And you certainly don't have to. And I'm not saying it's a best practice, but if you wanted to require proof of vaccination as a precondition to attendance, you generally can for your in-person conferences with the ADA issues aside. However, the rules are very different when it comes to employees, when it comes to staff. So when I'm talking about requiring it for attendees at your conferences, I'm not talking about staff. That's a very different issue. And if you required proof of vaccination by staff before they can attend your conference, that raises a lot more problematic issues. So for the same reason that it's problematic to require proof of vaccination before someone can return to your in-person workplace. There are a number of federal laws and state laws as well that protect employees from various forms of discrimination. You, of course, have the Americans with Disabilities Act, which has provisions that apply to employment, to the employment setting, Title II. But you also have a number of other laws religious discrimination, discrimination on the basis of various medical conditions and other things like that, that make it highly problematic to require someone to get a vaccine before they can come back to your workplace, at least without making some reasonable accommodation. And what that basically means, at least for now, and apparently the EEOC, Equal Employment Opportunity Commission, another federal agency, may be putting out some guidance in the near future about mandatory vaccination requirements in the workplace. And we'll have to see what they say about that. But for now, pending any guidance from the EEOC or other federal agencies like the CDC, generally speaking, it would be highly inadvisable to require someone to get vaccinated before they can come back to the workplace. Or if you did, you would have to make sure that anyone who does not want to get vaccinated for any variety of reasons, religious objection, medical objection, disability, something that, they're in a high risk category, that they don't think it's safe for them to get a vaccine, any number of reasons, you would need to make sure that they have an ability to have a reasonable accommodation that does not in any way disadvantage them, meaning essentially remote work, that they would be able to continue to work remotely, assuming they have already, that they're not going to be disadvantaged in any way. They're not going to, not get promoted or not get the same raise or worse, get terminated, because they're not coming into the office. You need to put them on an equal level playing field. And my strong recommendation, again, for now, is to allow anyone who wants to continue to work remotely, presuming that they can effectively do the job remotely. That doesn't work for all jobs, but it works for a lot of association jobs, to allow them to continue to do so for the time being. Again, this is all going to be reevaluated. There will likely be new federal guidance on that, but that's my guidance for now.
What should we be asking to have included in our contracts? And does it reach beyond hotel contracts and also include agreements for things such as speakers, transportation, AV, offsite catering?
So I'm not sure, Diane, that's a very broad question. What should you ask to be included in your contract? I don't know if you're talking about COVID-related issues, if you're talking about other issues.
I believe she was asking about COVID-related issues.
So
it's very general, I know.
Yeah, I've talked a lot already about mitigating liability risk, from attendees contracting COVID at your events. And I've also talked about the importance of trying to shift that liability risk to the greatest extent possible to other parties. I talked about hotels, but also to others, speakers, transportation providers, AV providers. For instance, putting in your contracts with them that you likely have, whatever you expect them to do to help mitigate the liability risk. So for transportation providers, sanitation protocols, other things like that, ventilation, things like that, getting them to attest that they will do that, for, on-site AV providers or on-site caterers, requiring them to wear masks at all times, to not have their employees show up if they feel sick, for catering, all sorts of protocols in terms of ensuring the health and safety of the food and drinks that are being served, for speakers, who are coming in, outside speakers, same kind of thing, mask wearing requirements, except when they're actually on the stage, so to speak, not showing up if they're sick, perhaps even having, proof of vaccination requirements. I said, you can do that, not for staff, but for others. These are some of the things that you might want to consider including. Now, on another set of issues, my colleague and I have spent, we've worked on probably 600, 700 association conferences so far over the last year, largely in connection with the cancellation or postponement of those conferences due to COVID. And there, again, I've done entire, hour-plus webinars on that topic alone. But what you want to do, and we're reviewing constantly now new contracts, for upcoming events, if the cycle continues, or even contracts that have been postponed or pushed back a year, we're reviewing new contracts. And there's so many different things that are important to go into your hotel contracts to help protect your association. But on the COVID-related front, the two big things that come into play are cancellation penalties and attrition penalties. So for cancellation penalties, the big issue of focus for the last year has been on what's called the force majeure clause. And that's the clause in a contract that if it applies, then you can generally, at least in theory, get out of your contract without paying any cancellation penalties. Early on in COVID, the first 6 months or so, we had enormous success in getting hotels and convention centers and other venues to agree to let our clients out based on force majeure termination, almost irrespective of how the clause was written. We had great success in doing that, in large part because most states and cities and counties were prohibiting these large gatherings from occurring. But as that has now changed, very much changed. I mean, in some states like Florida, there's never been any bans on large gatherings, and it's certainly not going to come into place now. And those bans have now been lifted, as you probably hear in the news, in a lot of other states as well. Even regardless of that, we've seen tremendous pushback from the hotel and convention center community in the last, I'd say, 3 months, 4 months, particularly this year, in that they're taking a much harder line. They're generally no longer accepting force majeure terminations. We have had a number of clients that have wanted to cancel their meetings in January, February, March, April of this year. These negotiations have gotten increasingly difficult, more difficult in some states than others. As a result, the negotiation over what the hotels, for instance, will accept in order to let you out of cancellation penalties. Like it used to be last year, in almost every case, either they would just straight up accept the force majeure termination, or we'd say, we'll rebook this meeting for next year or the year after that, whatever our next open date is for that meeting. And the hotels would accept it and waive any cancellation penalties, roll forward any deposits. But now we're seeing so many properties push back and want more. They want 2 meetings instead of 1. We just signed a deal for a client yesterday on one of those where it was a big citywide meeting, but they actually required to rebook for, I think, 2023 and 2026 in order to get out of their cancellation penalties. And this was the CVB that negotiated with the convention center and a bunch of hotels. We're seeing some where the hotels are demanding a future meeting plus some cancellation penalties. There's a lot of kind of tips and strategies and techniques that we've been using to help negotiate and get those things down to a more a reasonable level for associations. That's kind of beyond the scope of this presentation, but that's really important. The other thing is attrition penalties. So attrition penalties are the penalties that an association will get assessed if it doesn't meet its guaranteed minimums for sleeping room revenue and food and beverage revenue. Assuming there's sleeping rooms. If there's no sleeping rooms involved, then it'll just be typically food and beverage revenue. But almost every meeting contract, hotel, convention center contract has guaranteed minimums for those things. You can usually reduce, depending on how they're written, you can reduce those by a certain amount, maybe up to 10, 15%, up to like a year out. They're all written differently, but after that, you're stuck with those guaranteed minimums. Well, what we're finding now is that as associations contemplate the return to in-person meetings this year, what we've seen from surveys of members and even from some meetings that have occurred is that the attendance, and it's almost certainly going to be the case for the balance of the year from most associations, that if you hold an in-person meeting, you're not going to get the numbers that you had in the past pre-COVID. It is going to be lower numbers, and therefore you have the potential to get hit with very significant attrition penalties for failing to meet those guaranteed minimums for sleeping rooms and food and beverage. So it's absolutely critical that if you want to hold an in-person meeting this year, that you negotiate with a hotel, a convention center, or a venue to reduce those minimums significantly and or eliminate attrition penalties. We have seen a lot of our clients have great success in those negotiations because the properties are eager, they're desperate to have people come back. So they've been very flexible, a lot of them on that, not all of them. And some have said, yeah, we'll let you reduce it 15%, but we're not going to go down further than that. And so all of this factors in to your decision to hold an in-person meeting, because you don't want to hold a meeting and then get hit with massive attrition penalties. So you got to think about that before you go into your meetings and have those discussions with the hotels sooner rather than later. I think we have time for maybe one more question, Diane.
Yep. The last question is, whoops, I just went away here. If someone has a gas mask exception, example, Department of Corrections, from their doctor, would they be covered under the same exception during times of pandemic for PPE masks?
I'm not sure I understand that question. Yeah, maybe let's, instead of me trying to figure that out, why don't we just move on to one other question? If it's okay. And whoever asked the question, feel free to follow up with me offline. I'd be happy to try to help.
Okay, I think the other, one other question that I had was, is association income from virtual trade shows taxable, unrelated business income, and are there ways to structure these arrangements to generate tax-free revenue?
Okay, it's a good question. My most recent article that I wrote is on this exact topic that
Okay.
ASAE published a couple weeks ago. I will send you that article. It's really way too much to explain in 2 minutes, but short answer is, as ASAE quoted in the kind of subhead to their article, it's about as clear as mud. It's unfortunate, but the reason is that one of the exceptions to unrelated business income is the exception for qualified convention and trade show revenue. It's been in the tax code since 1976, but it was written at a time when there was no such thing as a virtual trade show. It was all in-person trade shows. Back about, I think maybe now about 14 years ago, the IRS came out with a revenue ruling, basically guidance from the IRS, that applied that exception to the then virtual trade show context. And as you can imagine, a virtual trade show 14 years ago resembles nothing like the virtual trade show of today. And there, what the IRS said in that guidance and that revenue ruling was that unless the virtual trade show was kind of ancillary and secondary and connected to an in-person trade show, that the exception from UBIT would not apply to that virtual trade show. If you take that literally and apply it today, and you take it literally, then what you would say is that unless the virtual trade show is conducted in conjunction with an in-person trade show and ancillary to it and conducted around the same time, that it's not going to qualify for the exception, and that exhibitor fees, paid by exhibitors for the virtual trade show might well be taxable as unrelated business income. However, there are some arguments to make that depending on how it's structured, if you really structure the virtual trade show to look and feel and smell just like an in-person trade show to the extent you can, I think there's an argument that the exception does apply. But anyway, take a look. I'll send you that article along with the other resources, and hopefully you guys will find this helpful, and you'll find my contact information on all of those articles. Feel free to reach out if you have any follow-up questions. Otherwise, Diane, thank you for moderating, and thanks for the opportunity to speak today.
Thank you very much. We really appreciate your expertise, and we'll be looking forward to those documents. Thank you.
That's great. All right, thanks everyone. Enjoy the rest of the conference.
Discover Mount Pleasant and all that Central Michigan has to offer.